For those of you who don't know Susan, Susan is Professor of Law at University of Auckland. She's one of the most well-known and respected corporate law scholars in the common law world, at least. Her main area of expertise is corporate law and corporate governance, with particular regard to theories of the corporate firm. In her work, Susan seeks to understand how the corporate firm developed, why it's so successful, and the economic and societal impact of corporations. Her research has been published widely in New Zealand and internationally. She's edited and co-authored treatises and textbooks, fan-edited collections, and also numerous articles. And her work has been cited and discussed by other scholars in the field, and also by courts at all levels, including the UK Supreme Court. Susan is currently writing her current monograph, The Making of the Modern Company, Entity Primacy in the 21st Century, which is due to be published by Hart next year. This afternoon, Susan will be discussing a particular aspect of this exciting project, which I look forward to hearing more about. The title of her paper is An Eversion in Thinking the Company as a Persona Ficta. So, Professor Watson.
Well, thank you, Mark, and thank you for the invitation. As Mark said, I'm from Auckland, and two interesting facts about Auckland, one of which you'll all know, and one of which you may not know. The first fact is that the time is completely reversed, so it's 12 hours different. So when you visit New Zealand, or when you come from New Zealand, you suffer from jet lag, because essentially you couldn't have a bigger time change. So that's the fact you probably know. The fact you probably didn't know is that it's sort of coming to the end of the New Zealand summer, just as it's coming to the end of the English winter. And as you probably know, New Zealand is quite a warm place. But yesterday I went to London, and it was warmer in London than it was in Auckland. Thanks, Mark. As Mark said, the topic is an aversion in thinking the company as a persona ficta. And I thought I'd start by trying to set out what are the key points that I want to make before I get into the paper itself. And I guess there are probably 4 key points that I hope that you take away from my talk, and which you probably violently disagree with most of them. The first point is this point about an aversion and perspective. So the argument there is that we should, why don't we talk about the company itself rather than shareholders, stakeholders, or even the board? So that's the first point. So that's what I mean by an aversion and perspective. Look at the company, or through the other end of the telescope, the company from the perspective of the company itself being the entity. And the second point is, what is this entity? Well, my argument is that essentially what we have with the company is a personified fund. So a fund that is a legal person, which I'll explain in more detail as I get through. The third point is that this personified fund emerged quite late in the history of corporate law. In fact, it didn't emerge till late in the 19th century in most jurisdictions. Probably emerged in the US and Germany first, and then emerged in the UK, and was sort of given judicial recognition in Salomon. And that essentially what you saw is the transition of the company from being a personified collective of people, association of shareholders, to becoming a personified fund. As you'll see when I work through the paper, there was precedent, and there is precedent in the law for corporations to be regarded as abstract personified entities. And in the first part of the paper, I'll talk about the persona ficta form that emerged in the 16th century, and the argument being that was just existed in the abstract as a separate legal entity from people, from land, from anything corporeal. But with the company, the modern company, my argument being, yes, it exists in the abstract, but it is based on something which is itself abstract, which is a fund, a personified fund of capitals, or fund of partitioned value. And then the final point, which I'll get to if I have time, is just some ideas, and these are very much emerging or new ideas, about what really does it mean in terms of this question about why are corporations or modern companies such a successful way of generating wealth. Well, why might it be that this particular legal form is able to extract wealth? And the kind of ideas which are just ideas at this stage, is that it's the fact that it's a personified fund has equipped the company in a unique way to transact for value, and also to capture forms of value from natural persons. And that's because it's separate from all natural persons as a personified fund. So those, I guess, are the key points, and now I just wanted to really work through the arguments that I would hope perhaps support this. So the first point is that, I guess, in our modern economy, we have actors, so that's a modern liberal economy. So to be able to fit within the economic framework, the company you'll have to think of the company as either being an actor itself or essentially being comprised of actors. So the kind of predominant law and economics views is essentially the corporate person is a legal fiction. So essentially you have a collective of actors who contract with each other, and corporate personality is a convenient heuristic formula or a kind of collective noun or a way of describing them, which is a legal fiction which doesn't have any kind of underlying reality to it. So then lots of analogies are used, and I'll use a New Zealand analogy because I'm from New Zealand and say that the idea of flock of sheep. So we might talk about, as a collective noun, a flock of sheep, but we know that the existence of that what matters is the sheep, and that the flock, the idea of the flock on its own, independent of the sheep, doesn't really exist. So in the same way we talk about if we think that the company is a legal fiction, then it's kind of parasitic on something that exists and it doesn't exist independently of it. So this is the idea of the legal fiction, the flock of sheep, the company being the same thing. And that's probably underpins certainly a lot of the nexus of contracts, law and economics ideas of the company. And then the second way is that you might say, well, actually the company is itself a person. And this is the argument that I try and set out in the paper. And I use the term persona ficta, which is an old and slightly misleading term, actually, because persona ficta really doesn't mean a fictitious person. It means an artificial person, which is a person that is created by the state or created in some way, which is an artificial person, but not necessarily, therefore, not a real thing. So if you remember from Salomon, or if you've read Lord Cook of Thornton's essays, he writes about, these people write about the company being a real thing. So even though it's artificially created, it's a real thing. And an artificial person can be a real thing. How do we know that? Perhaps it has an existence that is independent of the natural persons who are connected with it. And also this real thing is a separate legal entity that can transact independently. So that's the argument in my paper, is that actually the company maybe once, arguably probably, it was a legal fiction, but the modern company is a persona ficta, an artificial person, a real thing, but it's a personified fund. So it's a real thing based on an abstract being a personified fund. So to try and support the argument, we'll say where this idea of the persona ficta comes from. You can go back into the history of the corporation. And in law, we use the terms corporation and company quite interchangeably when we talk about companies or talk about corporations. So as you know, in the US, they talk about corporations. In our jurisdictions, we tend more to talk about companies. But essentially, in a kind of legal sense, even the modern company probably is a type of corporation rather than a company of persons. So probably the terminology does point at some deeper meaning. So the history of corporations existed, arguably universitas existed in Roman times, certainly existed into the Middle Ages, and of course they weren't, in fact, in the Middle Ages they weren't joint stock corporations based on a fund. They were a system of governance. So the state would create, or the Crown would create corporations to govern cities. There were ecclesiastical corporations. There were lots of different forms of corporations that existed. And Pope Innocent IV, which is the guy on the left in the slide, he was the Pope, I think, in the 13th century, but before he became the Pope, he was a distinguished legal scholar. And he's kind of attributed with the idea of coming up with what Maitland called the Italian theory of the corporation, or what we might call this idea that you could have a separate legal entity or a legal person that existed separately from natural persons or human persons. And the reason that he's credited with coming up with that idea is some statements that he made in a commentary. And he talks about, and again, it's quite disputed whether he was really the person who invented it or came up with the concept, but he talks about a universitas, which was the term they used for corporation in the 13th century. And he talked about that a universitas could not be excommunicated, even though the wrongdoing monks who were members of the universitas could be. So that's used as evidence by some scholars to say, well, actually he was thinking of the universitas, or the corporation, existing separately from its members. And there's some dispute about that. But I guess even if there's dispute about whether Innocent IV invented this concept, certainly it was brought into the common law by Sir Edward Coke in the 16th century. And Maitland writes quite a lot about what he calls the Italian theory of the corporation, because he thinks that the origins were through Innocent IV. But Sir Edward Coke brought it in a case that probably a lot of you are familiar with, the case of Sutton's Hospital, which was a case of 1612. And it was pretty clear from that case that Chief Justice Coke considered corporations to be persona ficta, or artificial persons. And you could say, when you look at the facts of the case, that it suited Cook to do that, because on the facts of the case, which was the case of Sutton's Hospital, he wanted to uphold the existence of a corporation. And if we look briefly at the facts of the case, you can see why. So Sutton's case was about, I don't know if any of you have ever visited the Charterhouse School in London, so it was about the attempt by Sutton to establish a corporation for charitable purposes that would run a charitable hospital and school in London. And Sutton was actually the richest man of the Elizabethan ages. He's not really remembered very much, I don't know what that means, but he wanted to leave this land so that this charitable corporation could run the school and hospital. James I granted the licence for the school and hospital for the needy in the grounds of the old Charterhouse. And he was known as Rich Sutton, and when he died, he was one of the richest men in England. Now, when he died, his heirs, Sutton's heirs, challenged the validity of the corporation. And the argument that they used was that at the time the corporation was formed, it didn't own the land. So they said this corporation wasn't based on anything. And the idea at that time was that you had to have a corporation based on something. Lord Cook didn't agree with the heirs and found against them. And it's interesting because nowadays Cook wouldn't have been let anywhere near the case. He was actually one of the trustees of the hospital. He was actually quite close personal friends with Cook, and they were all part of the government. So it's interesting when you think, well, maybe we have this entire persona ficta, separate legal entity idea, because Cook wasn't prepared to let the heirs win in this case. So he introduced this arguably Italian idea of the corporation into the common law, and Maitland's quite kind of critical about the kind of form of it that came into the law. But nevertheless, he did exist it and introduce it, and the case of Sutton's Hospital became one of the foundational cases of corporations law that applied to all types of corporations. And so this comment most quoted from the case, Chief Justice Cook said the corporation was invisible, immortal, and resting only in intendment and consideration of the law. And in a less quoted passage, he talked about it existing in abstract, and he also was the person who talked about how corporations couldn't commit treason, be outlawed or excommunicated, for they have no souls, neither can they appear in person but by an attorney. So clearly the idea that this was a separate legal entity that existed in the abstract was part of what was underpinning what Cook was saying. And the other very clear statement that comes out of Sutton's case is the idea that it's the source of corporate personality or status as a legal person was through the Crown or the state. So this concession theory idea certainly emerged in Sutton's case. Now, if we sort of move forward to to the 18th or 19th century, you can see, of course, in the period between Sutton's case, which was decided in 1612, and in the 18th century, you had the emergence of a different type of corporation, and that was the joint stock corporation. In joint stock corporations, they were given charters, so they were legally a type of corporation, but they differed from other types of corporation because the shareholders had a joint stock fund. And joint stock funds people talk about them being one of the foundations of capitalism, because what they did is they allowed, for accounting purposes, they allowed investors to separate the funds that they had invested into a joint stock fund that existed separately for accounting purposes from the shareholders. And that enabled them to put funds into ventures. So as a legal form, though, the joint stock company didn't really emerge till 50 or 60 years after the case of Sutton's Hospital, not until sort of more into the late 16th, 17th century. And therefore, by the 18th century, you had Blackstone and you had Kidd, who wrote the first treatise on corporations, saying that they didn't regard corporations as separate legal entities that existed in the abstract. In fact, so Kidd, in his text on corporations, which he actually wrote when he's in the Tower of London on a charge of high treason, so found a way of filling in his time, he said that corporations were a collection of many individuals with the capacity of acting in several respects as an individual. So a shift back, or a shift towards regarding a corporation as essentially if you like, closer to being this idea of a collective noun, or based on a collective of people, had emerged in the 18th century. And in fact, treatise writer Kidd sort of indirectly referred to Sutton, because he said there's nothing incorporeal or abstracto about a corporation made up of natural persons. And he said, on this principle we may account in a satisfactory manner for many of the incapacities attributed to a corporation aggregate, without having recourse to the quaint observations frequent in the old books, that exists merely an idea and that it has neither soul nor body. So completely different understanding of the corporation, probably brought about by perhaps two things. One, that you had the joint stock corporation, which had become a very important form. And secondly, you had a shift from the Middle Ages, where only legal persons had legal standing, to the kind of emergence of private law in the modern liberal economies, where all human beings or natural persons had legal standing. So that kind of those two shifts. So when we had general incorporation from about the mid-19th century onwards, you had all these different preceding legal forms that existed. So you had corporations or joint stock companies that had charters that were formed by statute. So in terms of law, they were types of corporations. You had a contractual form where assets were settled on a trust, which had many of the characteristics of a corporation but wasn't a legal person. And the question really for the courts, what would happen is, once you had incorporation through following a process in a statute and the general incorporation statutes, what was the source of the legal personality of these modern companies? And I guess the argument in the paper is that the modern company transmogrified from being an association with shareholders who held shares in a joint stock fund, and therefore legal personality, sort of a type of legal fiction which was parasitic on the shareholders, but treated as a juridical person because it was an incorporated company, which was probably the idea which was carried forward from the joint stock companies of the 18th century, until you had this legal separation of the people, the shareholders, from the fund. So then you switched around till you had essentially a persona ficta, or a fund of capitals that was personified, and it derived status as a juridical person from the statute. So You could argue that right from the beginning of the General Incorporation statutes, the status as legal personality was derived from the statute, or maybe it was from the collective of shareholders. I suspect no one really cared that much. But by the end of the 19th century, once you had the legal separation, which we all know about, was identified in Salomon, of the shareholders from the fund, essentially what you were left with was a personified abstract, which was the joint stock fund. Now, the evidence, and there's sort of lots of evidence of this gradual, and I think it's a bit like someone used an example in a talk I went to last week about this test that's done with students where they're asked to watch people playing famous psychological tests, throwing a ball, and they don't notice that a man dressed as a gorilla comes into the room. And I think it's a little bit like that, perhaps with the joint stock funds. There's so much focus on a company of persons, or the idea of companies being comprised of persons, that we ignore the other key aspect of it, was that it was always based on a joint stock fund. And that joint stock fund was separate for accounting purposes, but then once you had the legal separation of shareholders, then you were left with something in the corporation, which was the joint stock fund. And the joint stock fund, which had always been separate for accounting purposes, was separate for legal purposes. And essentially it's something we always accept. So if we jump to kind of current significance, or why this might matter, well, I think there's general acceptance that we do have the separation of a legal entity from shareholders. So one of the key characteristics of company law or corporations law across the world is that you do have that legal separation, brought about perhaps as a consequence of limited liability, but something that developed after the General Incorporation statutes, but was in place in most jurisdictions by the end of the 19th century. So despite that, we continue to think about companies from the perspective of people. We talk about them from the perspective of shareholders, or we talk about them from the perspective of stakeholders, rather than the perspective of the entity itself. So just, and this will be familiar to you if you think about agency theory, tends to be focused primarily from the perspective of shareholders, but of course also agency theory takes account of stakeholders. So we talk about the agency problem for shareholders, or the agency problem for stakeholders in entrusting their funds to managers. And Adam Smith talks about the agency problem that existed for joint stock companies in the 18th century, although I would argue he's talking about a different legal form, because there wasn't separation of the joint stock fund from shareholders at that time. Even director primacy, which of course Stephen Bainbridge is most famous for, the idea that you look at, he would even look at corporations from the perspective of directors. So again, it's directors and their relationship with shareholders and their, as he sees it, roles to maximise shareholder value that he's talking about, but he's talking about the company from the perspective of directors. So the paper, I guess the argument is the paper is arguing for an inversion in thinking, so that we shift to thinking about the company from the perspective of the entity itself. And our starting point should be the entity itself, not shareholders, stakeholders, the board, corporate organs, any other aspect. And then essentially, if you accept the argument I'm trying to put forward, is essentially it's a persona ficta, it's a personified entity based on a fund of capitals that we have when we have the company. And then the final part of the paper, which is really speculative, there are all sorts of consequences that you can think about because of this, and it's probably pretty easy to think about what some of those might be. But the one that I concentrate on is probably the idea about the question that's at the beginning of the paper is, why are companies such a successful legal form? Why is it the business vehicle of choice across the world, but also how are they so effective at growing wealth and holding on to wealth? And if you think about what Adam Smith wrote about corporations in the 18th century, about the agency problems, despite these identified agency problems for shareholders, I don't think anyone would question that generally across time in a kind of mega meta way, the corporations do generate enormous amounts of wealth. So why is that? And what might this idea of thinking about the company from the perspective of the entity itself enlighten us about why that might happen. So I guess 2 points, or several points that are, again, like I said, really speculative about this. Well, the first point is that if you think about the company, if you avert your perspective to think about the company from the perspective of the entity itself as a fund of capitals, well, because it's a fund of capitals, it can't do anything on its own. So you saw during the late 19th century an increase or rise in significance of the board. So in the mid-19th century, you could, in theory, have formed a company without needing to have directors at all. And it's only later in the century that it became compulsory that you have directors. And the reason for that could be that because of the legal separation of shareholders from the company, you needed someone, or you needed a body to make decisions for the entity. So if you look at the corporation from the perspective of the entity itself, what is the role of the board? Well, the role of the board, you could say, was actually essentially to transact for value. So the board is acting on behalf of the entity, just not the shareholders, but as a fund of capitals, and in transactions trying to transact for value for the entity itself. So every transaction the board is deciding, well, is this, through managers, through delegates, is this transaction in the interests of the company itself considered as an entity? So the board transacts for value on this model. And the second part is that also the corporation, because it's, even though it's a artificial person, it's a real thing, as it operates in the world, it's able to extract value through the world. It both creates externalities, because it is an effect in the world, but it also extracts for value. It extracts value, because, and the value that it extracts will be from the things it develops as it operates through the world, like brand, goodwill, all those things that it has, it is able to attract to itself and extract value from. And then thirdly, the corporation has employees, and this idea that essentially a firm has an internal and external aspect. Well, in the paper, and again it's speculative, I argue that actually a company might be at the core of a firm, but a company isn't the same as a firm, because a company essentially has employees that it's able to extract different forms of value from that isn't necessarily in a transactional manner, because the employees, as they operate in and around the firm, create types of value that the firm, or the company rather, because it's legally separate from the employees, is best equipped to extract. So, for example, and there's very good books by Chandler that write about the sudden growth in scope and scale that existed in the late 19th century in corporations, and also work by Oliver Weinstein that talks about the different ways in which and they say firm, but I would argue they really mean company, is able to extract value. And they talk about how the capacities and knowledge of the organisation are greater than the sums of the knowledge of the people who work for it or are connected with the organisation. And Weinstein talks about how the skills of the firm exist, replicate and develop, even though the individuals that make up the firm change and its structures evolve. And then the second point he makes is about the skills and knowledge of each participant as fragments of the knowledge and skills of the organisation can only be significant and effective within certain contexts which are related to the skills and knowledge of other participants. This idea that they interact with each other around the firm and actually around the company, and that the company, because it's separate from the natural persons, is best equipped to extract that value. And then the third thing he talks about is processes of learning and production of knowledge are based on shared codes, beliefs and representations. Any form of durable organisational learning requires mechanisms for the codification of knowledge and interaction procedures. And again, the company being able to separate that from the natural persons and extract it in a much stronger way. And then finally, the organisational architecture necessary for organisational capabilities. And the fact that the Persona Ficta, an entity that is a fund of juridical persons separate from natural persons, has the longevity, potential longevity, that it can lock in those forms of value over the long term and separate them from the natural persons who are the employees, but also transact for value with third parties, means that that as a business form, That's what gives the modern company its vast superiority over other forms where you don't have that separation. And if you read work by Alfred Chandler, he illustrates that really graphically in the big corporations that emerged, particularly in Germany and the US in the very late 19th century. So you think about Siemens in Germany, or you think about Rockefeller and the way that they were able to create systems that allowed them to produce goods at much less cost because they had these vast organisational systems and were able to scale them up. So the example he uses for Rockefeller and oil is that essentially the cost to produce a barrel of oil reduced by 90% over about a 10 or 15-year period because of the way they're able to scale up and they're able to capture and create these organisational systems separate from people. So I guess, and again, key points which I'd then welcome your feedback on. So this idea of the persona ficta, or this entity, that even though it's abstract, it is based on something. It's based on an abstract concept of this fund of capitals. It is able to transact actively as a legal person for value. And that's compared with the idea that the company is itself a nexus of contracts between participants, or the idea that some people have that essentially the company is a counterparty to contracts. So I'd argue the company is much more actively involved in transacting for value. It's not a kind of passive counterparty to contracts by participants, or it's not just a nexus of contracts by participants. It actively seeks out value through its board and delegates. Second argument, essentially that it's a fund of capitals, not of natural persons. It's entirely separate from all natural persons, and that's its kind of greatest value or worth. It can capture forms of value from natural persons because it exists over the long period, and it can use them to generate more value, so it combines these forms of value, and it's forms of different types of capital, organisational systems. Of course, they can gather data, fragments of knowledge from different natural persons, and also skills contributed by participants. And the final point, which I won't spend any time on, is that one of the kind of mysteries of when you first study corporate law, I think one of the questions you ask is why are the courts so reluctant to lift the corporate veil? Why is it so hard to make shareholders liable? And it's discussed a little bit in the paper, but the fact that actually if it is a fund of capitals and it is a legal person, then you've got actually not just strong form entity shielding, you've got near perfect entity shielding, because you have this legal person that contains capital, not the shareholders, and that's why it's so difficult you've got essentially 2 degrees of separation between the shareholders who, behind the corporate veil, essentially have a legal person that is a fund of capital, and then you have a degree of separation to the shareholders. So 2 degrees of separation that make it so difficult for courts, and why courts are so reluctant to lift the corporate veil. And there's a few quotes in the paper from Prest and Petrodale where Lord Sumption talks a little bit about the significance of the company. It seems to adopt this kind of idea that both the legal and economic significance of it. But I'd actually now welcome your questions and comments.
Questions or comments for Susan?